I want to dive into all of the legal implications here immediately with my first guest. That's Hans Von Spakovsky. He's the manager of the Election Law Reform Initiative and a senior legal fellow at the Meese Center for Legal and Judicial Studies at the Heritage Foundation. Hans, great to have you with us, sir. Thank you.
Well, thanks for having me. I'm sure when you heard that, Vince, you were thinking, gee, am I suddenly in Venezuela or someplace like that?
Well, it is so cartoonishly authoritarian. My view is that if you're not awake at this point, there's no chance of waking you from your slumber.
No, that's true. And look, it was a split decision, as you know, 4-3 with 3 dissenters. So in essence, you had 4 state court judges telling the more than 4.5 million voters of Colorado that we're taking away your right to vote and your right to choose who you think should be a candidate for the presidency.
And all 7 of these judges were appointed by Democrat governors. All 7 of them. So so even they are split on whether or not they want to be authoritarian right now. So they've removed Trump, and the basis for this, as I understand it, is they've concluded without any court, without charges or without convictions, that Donald Trump is an insurrectionist. Therefore, because of Section 3 of the 14th Amendment, he is not allowed to appear on a ballot for president of the United States. Do I have that right?
You do. And, you know, what's so absurd about that is that, where do they get off thinking that they have the ability to do that? Because engaging in insurrection or rebellion, that is a criminal violation of federal law. No such charges have been filed against Donald Trump anywhere. In fact, the only time this has happened was, as you'll recall, in the second impeachment resolution of the House of Representatives. They did include incitement to insurrection when they approved it in January 2021. And, of course, a trial was held in the Senate, and the U.S. Senate acquitted Trump. And yet these 4 judges think that they have a right to substitute their judgment for that of the U.S. Senate, which represents all 50 states in the country. That's an example of their judicial arrogance.
It is. It really is amazing. I did see of these judges, not only were they all appointed by Democrat governors, one of the commonalities between the judges who said to take Trump off the ballot is they all apparently went to elite and Ivy League institutions. The 3 judges who were in the dissent, I think they all went to the University of Denver. So the one thing that the most authoritarian judges have in common is they went to elite universities, Hans. What do you think of that?
Well, that doesn't surprise me. But look, the other thing people need to understand is that these judges defied the U.S. Supreme Court in making this decision. And the reason for that is, look, they didn't even need to get to the issue of did President Trump commit insurrection or not, because Section 3 of the 14th Amendment, which disqualifies you from holding office if you engage in insurrection or rebellion, it only applies to people who previously were either a member of the U.S. Congress, a state official, or an officer of the United States. And the Supreme Court, U.S. Supreme Court, has held in more than one case that term, an officer of the United States, it doesn't refer to people who are elected to office. It only refers to people who have been appointed to serve in the federal government, such as, for example, a federal judge who's been appointed and confirmed by the Senate, or a cabinet secretary who's been appointed and confirmed by the Senate. So that section, it doesn't even apply to Donald Trump.
Because I would imagine that the belief is that the voters have the ultimate authority over who gets a job and who doesn't.
No, that's exactly right. The other, and look, these 4 judges just basically thumbed their nose at the U.S. Supreme Court's interpretation of that particular language. The other thing that they did is, look, there's case law out there saying that Section 3 is not self-executing. What that means is no court can simply enforce Section 3 of the 14th Amendment. It can only be enforced if Congress passes a statute providing for enforcement of Section 3, and Congress has never done that. In fact, one of the dissenters in this opinion points that out. And again, the majority they just glazed over that and said, no, of course we can enforce it, even though there's case law saying there's no enforcement mechanism for this.
So there's also never been an amendment to the Constitution that I'm aware of that has changed the qualifications for President of the United States, right? The Constitution lays out only 3 specific qualifications. You must be 35, you must be a natural-born citizen, and you must have lived in the United States for at least 14 years. That's it, right? Unless I'm missing something.
No, that is it exactly. And in fact, during the Trump administration, you may recall, California passed a statute saying you couldn't be on the ballot as a presidential candidate in California unless you disclose all of your tax returns. And the federal courts threw out that law saying, states, you cannot impose additional requirements over those 3.
And yet they still try. I mean, California today is trying this. My understanding is California, in their first justification for it, who is this, Corey, one of the top prosecutors in the state? They released a letter, and it was the lieutenant governor. The lieutenant governor. They released a letter today, and they accidentally wrote that the president is supposed to be 40 years of age. They literally don't know what they're talking about. They had to retract the letter and then release it again and say that they have to be 35. I mean, Hans, they don't even know what they're talking about, and they're trying to bring us into a constitutional crisis.
No, that's exactly right. And look, for those folks out there who don't like Donald Trump, you need to keep in mind that these courts are basically taking away your right to choose. And this is wrong the very same way, they should be concerned about, well, the shoe could be on the other foot sometime. And for those who say, oh, that'll never happen, the shoe's already been on the other foot before. Remember, during the Obama administration, when he first became president, there were a bunch of lawsuits filed around the country saying he's not qualified to be president because he's not a natural-born citizen. And those cases were all tossed out, as they should have been. And these cases need to be tossed out. One thing that's clear, Vince, is the only place you can appeal from a state Supreme Court is to the U.S. Supreme Court, and I have no doubt that's going to happen very, very quickly.
Okay, so let's talk about that next step. I was asked earlier today, somebody asked, is it possible the Supreme Court doesn't take this up? My impression is there's no chance. This is, if there's anything that falls squarely into a case the court has to take, it is something as pivotal as a United States, as one state, deciding that a presidential candidate will not appear on their ballot.
Well, there's no law saying they have to take the case, but I just don't see how they could possibly turn this down because of what you just said. Because not only does this affect voters, the 4.5 million voters in Colorado, but this could affect 170 million registered voters across the U.S., particularly if other states like California start following the lead of this bad decision by the Colorado State Supreme Court.
It's remarkable. So how quickly does a court take this up? I've heard the phrase rocket docket. What does that mean?
What that would mean in this case, and I think the court would realize that if they took it, they would have to make a decision absolutely as soon as possible. So if they took the case, I think they would set up a very short schedule. They would tell folks to file briefs quickly. They would schedule oral arguments, and they would issue a decision as fast as possible. They have to because, as you know, the first primaries are only 2 months away, and election officials are already printing up the ballot. So there can't be any margin of delay in making this decision, particularly because, look, this isn't the only challenge like this. There are lawsuits proceeding along these same grounds in other states, including Michigan and Oregon, and we need a decision from the Supreme Court to short circuit all of these state court cases.
Yeah. And notice what's not happening today. Notice that Donald Trump's top opponent, Joe Biden, is not condemning this. He's not. So this is supposed to be the unity guy, right? By his own declaration. Supposed to be the guy bringing us together, healing us as a country. Instead, what he's doing is he's perfectly happy to indulge this authoritarian chaos. And he's not stepping up and saying what he should say, which is, this is out of control. He needs to be on the ballot. It's up to the voters. It's not up to an individual state court. But he won't say that because he's for this kind of tyranny, Hans. It's unfortunate to say.
Well, I think you're right. Also, given the fact that this is the first administration in history to file criminal charges against what may be their chief opponent in an upcoming presidential race.
Yeah, and we're seeing exactly what that looks like right now. And Jack Smith. Well, lastly on this, just because you brought it up, but it's an important point, I think. Jack Smith, who is the Biden administration official who is hassling Donald Trump with each passing day, he is trying to rush his case ahead of the election. In your experience, Hans, is that standard practice at the Justice Department that you have to get a conviction of a political candidate prior to the election? Or can events dictate that maybe it should wait?
Well, in this case, he's asking the Supreme Court to skip the entire appeals process, which is extremely rare, and he hasn't given any good reason for that to happen, particularly given that he waited years to file these charges, and now suddenly he wants it decided so that he can get a trial in the middle of the primary and campaign season. There's no reason for that from a legal standpoint other than a political reason.
All right. Hans Von Spakovsky, thank you as always for your expertise on this subject, elections in particular. Always good to talk to you, sir. Have a great Christmas.
Thanks for having me.